My name is Harry. I'm from London.
Meghan Markle here. Okay, today is January 13, 2022. It is 3:22 a.m. I'm continuing with the ruling of Virginia versus Andrew. All right, this was the last prayer that I read. So let's go back to the agreement. Okay, let's see here. All right, this is where I left. Now let's continue. Let me read the last paragraph here. Section 1 contained the agreement of plaintiff and Jeffrey Epstein to dismiss plaintiff Florida case upon receipt of a monetary payment. Section 2, which occupied 1.5 typewritten pages, contained, among other things, language by which first parties, generally Ms. Giuffre and some others, released, quote, second parties, generally Epstein and some parties, and any other person or entity who could have been included as a potential defendant or the potential defendant from all and all manner of claim that said first parties ever had or may have against Jeffrey Epstein or other potential defendant. The defendant insists that he was among the other potential defendant and therefore was released by Miss Virginia from all and all manner of, okay, that's actually in quote, all and all manners of, end quote, claim that she, quote, ever had, end quote, against him. My goodness, how arrogant little piece of, you know what. He didn't, his name is not in it. I'm telling you, they want everything. They want everything. Okay, Ms. Giuffre maintained with equal adamancy that he was not among the other potential defendant that the parties to the 2009 agreement had in mind. Okay, I see. The basic principle of Florida law that governs this aspect. So in other words, if Andrew is claiming to be part of this, so which means Florida could go after him and sue him. I mean, this guy it's like pretty much trying to play all part. So now that this was already done, so if Florida, the government in Florida did not recognize him as part of the defendant because they were only going after Epstein. So now he's saying he's part of this. So Florida could easily go after Prince Andrew. He should have just shut his mouth and tried to prove he's innocent. Because the more I read this, the more I could see he's putting himself in more trouble. Okay, let's see here. The defendant insists that he was among the other potential defendant and therefore was released by Ms. Giuffre from all, quote, all and all manner of, okay, I read this already. The basic principle of Florida law that governs this aspect of the parties' dispute are clear. This is what the judge is saying. Unless contract language is, quote, unambiguous and free of conflicting inferences, end quote, ambiguity, quote, must be resolved as a question of fact. This is what I was saying. The court don't want to hear hearsay. They want to see concrete evidence. So there was no concrete evidence here for this judge to go along with what Andrew was saying here. In other words, unless the term of agreement leave no reasonable doubt about the intent of the contracting parties, the ambiguity must be resolved by the tier of fact. I did say that. The court only accepts facts, not nonsense. Okay, ordinarily a trial jury. This is what it's saying here. So the jury must hear all the facts. The court may not resolve any such ambiguity on a motion to dismiss the complaint. So in other words, the judge is saying, hey, don't blame this on me. I'm not going to dismiss it. You just have to go to trial and prove yourself. Okay, whether a contract is ambiguous, quote, is a question of law, end quote, specifically whether the agreement is whole or by its term and condition is, quote, reasonably susceptible to be more than one. Okay, there's a whole bunch of things here. Interpret it, end quote. That is so even where both sides insist that language is unambiguous but ascribe materially different meaning to it. So in other words, they have to go to court and dispute it and say, how is it that you're part of this? I mean, he's putting himself in more problem. You saying here you were part of an Epstein sex trafficking thing. You acknowledge you are guilty of that because Epstein have said to the court he is guilty. He is a sex offender. So this is what Andrew is saying, that he's going into this trial. If he doesn't how do you call this? If he doesn't settle, and if he goes to trial, he's already telling the jurors that he is guilty already. That's what he's saying here. Okay, in this case, everyone agrees that the phrase, quote, could have been included as a potential defendant, other potential defendant, end quote, must mean something. No doubt that is so, nor is there much doubt that better drafted probably could have been eliminate any uncertainty as to meaning. So the judge saying that because what is it? I think David Allen Green, one of those UK attorney, have said, I've read and share with you where he said, I'm usually dealing with court document with the U.S., but I'm not. In other words, he's not licensed to work in the United States and stuff like that. So he did say that this could not is not drafted well enough. Even in the UK, Virginia could sue him there too. That's something that the UK, I guess, trial or something, UK government will not acknowledge that agreement that Jeffrey Epstein signed because there were no concrete evidence in there. His name was not part of it. All right, so here, nor is there much doubt that better drafting probably could have eliminated any uncertainty here. So in other words, the document was not very well documented. What they did here, whoever drafted here, they want to be part of it, and at the same time, they don't want to mention their names. That's what they were trying to be slick here. So the court does not recognize it because there is no concrete evidence of anything here. So it's like I was saying, anybody who is sex trafficked could easily say, oh, I'm covered under this Epstein thing. All right? No name was mentioned. Okay, let's continue here. Okay, is that the one? Okay, in this case, everyone agrees that the phrase, okay, I did with that. We perhaps should begin with the question of what was meant by, quote, could have been included as a potential defendant. So who are these people? As opposed to, quote, could have been included as a defendant. One might suppose that whether one was or could have been included as a defendant, not included as a, quote, potential, end quote, defendant is clear enough, although even that seemingly simply supposition, as we will see, is not accurate in the context of this case. Yeah, they didn't accept this. Okay, but the concept of inclusion, end quote, as potential defendant, end quote, is even less capable of definition. If the quoted language from the Section 2 of the 2009 agreement, that is, the phrase, quote, could have been included as a potential defendant. All right, so there's the context here. He put it here. Indeed, we might have begun with the fact that the 2009 agreement defines, quote, other potential defendant as any other person or entity could have been included as a potential defendant without specifying in what defending brief sought to solve that problem by asserting that the 2009 agreement defined other potential defendant as any other person or entity who could have been included as a potential defendant in Ms. Giuffre's lawsuit against Epstein, despite the fact that the italicized word do not appear in the 2009 agreement. Plaintiff, however, take the same view. All right. The 2009 release by its term encompassed only claim against Epstein and other potential defendants who could have been included as a potential defendant in the Florida complaint. Accordingly, the court accepts the parties agreed glass on this point for the purpose of this motion. The judge accepts the motion, but the thing is, it's not clear who could have been in it, who could exempt from this motion. All right, so in other words, this judge accepts the agreement and at the same time reject Andrew's claim because his name was never mentioned in there. This agreement could have been drafted somewhat a bit better. So no specific name was mentioned to be included in that because nothing beside Epstein and Virginia's name is there. So no one can claim they cover under that. A lot of people shaking under their boots right now. Okay, was intended to mean someone who was not actually defendant when the 2009 agreement was signed. Okay, so I read this to sort of disrupt the flow of the thing. Let's go back to this. If the quoted language from section 2 of the 2009 agreement, that is the phrase, quote, could have been included as a potential defendant, end quote, this is what it mentioned here, okay, was intended to mean someone who was not actually a defendant when the 2009 agreement was signed, but who might have been made a defendant previously if the plaintiff had named him or her as an actual defendant, then the word potential will be entirely superfluous. Okay, that is so because the language will mean exactly the same thing with or without the word potential. But put another way, the phrase under consideration will mean exactly the same thing even if one deleted the word potential entirely. Wow. It is a basic rule of contractual construction that contract should be construed whenever possible in a manner that gives meaning to every word and phrase. Oh, shit. So, in other words, the judge is saying anybody, so pretty much anything that a contract has, every word that is written on it should have a meaning. So don't waste people's time reading nonsense kind of way. And that should be a very good lesson for those who are in law school. This is a very good lesson to learn what it means, what the judge is writing here in terms of contract agreement. When you're writing a contract to for somebody, whatever you're writing, you need to be very clear exactly what you are saying. But I think whoever wrote this knew exactly what they were doing. In other words, they knew they are part of this, and at the same time, they don't want to put their name on it. So if nothing ever raised, their name will never be mentioned. But if thing is raised, just what is happening here, so at least they could go under this umbrella to throw their coin here. They say, I'm under this. But the judge is saying here, when you're writing a contract, you need to be very specific what you mean in the contract. So this is this here. Okay, the presumption is that contracting parties do not include words or phrases for no purpose. So in other words, the judge is saying here, when you writing your contract, they don't put words on a paper without a meaning behind it. There's a reason for it. All right, so this is what the judge is saying here. Nevertheless, the parties have briefed this matter as if the word potential were not in the agreement at all. And as the court sees no other appropriate course, it will do as well. It sees no way to construe it in a manner that will give non-redundant meaning to the word potential. So the judge is saying here, the agreement in 2009, who are the potential? Nothing concrete was presented to him for him to throw the case out. So when you're writing a contract, you need to be very specific and say what you mean, write what you mean. Don't just put words into a paper and expect a judge to go with it, even though we assume what you mean. So you have to be concrete with what you mean. Because in the eyes of the justice, which should be played all the time, should be blind, okay, to everything. And then until they hear the concrete evidence, that's when their eyes should be open to determine who's right, who's wrong. Okay, so we come to the question of what was meant by the phrase could have been included as a defendant, end quote. At one level, of course, literally anyone could have been included. That's what he's saying. And I did mention it when I was reviewing. I said anyone could mention their name, even though they not even associate with Andrew. All right, as long the arrest them for sex trafficking. Let's say, for instance, just as an example, because he had been convicted, the Duggar guy. All right, let's say they arrest him for something. He could have easily said, "Oh, I'm part of this. I'm covered under this umbrella," when in fact he has nothing to do with it. You understand what I mean? That's what I'm saying here. So anybody could easily put their name under it. So I'm not going to read this. Okay, as a defendant, if the plaintiff had wished to include someone else, anyone else, as a defendant, she easily could have done so. Okay? So they didn't mention Andrew here. I'm telling you, a lot of people are shaking under their boots here. Someone can be included as a defendant in a lawsuit simply by including that person's name in the caption of the complaint. Okay, so the judge is saying, if you wanted your name to be part of it, you should have mentioned your name in it. All right, so he's playing both sides. Okay, nothing else required. But neither party takes that position, despite the fact that it will be consistent with the literal term of the 2009 agreement. Rather, the defendant argues that he could have been included. Wow, the judge is not playing. As a potential defendant in the Florida case, because Ms. Giuffre made a general reference to royalty in her Florida complaint, even though it did not name Prince Andrew as a defendant, nor even mention his name. See, I was right. Wow. In some case, even though they play Epstein people play Virginia, and at the same time Virginia play them too, because Virginia didn't mention specific name. So if he's saying here royalty, there are plenty of royalty out there. Andrew is not the only royalty out there. You understand? I don't want to mention any name to this garbage, but anybody could have easily be any royalty. All right, so that's that. This is what the judge is saying here. All right, and the Florida case, because Miss Giuffre made a general, all right, just general reference to royalty in her Florida complaint, even though it did not name Prince Andrew. Okay, Andrew is a royalty, but in general, he's not the only royalty that is. Okay, as a defendant, not even mention his name. So the judge is making that clear. I wish I could see the complaint that led to Virginia doing the agreement with Epstein. I wish I could see that one. Okay. Plaintiff rejoined that Prince Andrew could not have been included as a defendant in the Florida case because he was not subject to personal jurisdiction there, and in any case, too, the claims that the plaintiff brought against Epstein in the Florida case were based solely on the 18 U.S.C. 2255, which I read that on video 1. Okay, I Google it and search it. Okay, which create a federal civil cause of action in favor of anyone who, while a minor, was injured and consequences of a violation of any of several federal criminal statutes. As to the latter, she contended that Prince Andrew could not have been sued in the Florida case under any of, all right, that's part of the thing. Let's see. Any the section 2255 predicate statute because there was no basis for doing so. Okay, so the, what is it Virginia saying here? Maybe, okay, maybe, I don't know. Andrew probably did not have sex with her in Florida. That's what I'm thinking here. But it happened in New York. So that's what Virginia is saying here. So if Andrew's claiming that he should be part of it, I'm telling you, he's gonna entangle himself. He probably gonna have to say that he had sex with her in Florida. How come she didn't sue? But anyway, this is, I'm telling you, this is crazy. So this is all the section of under the law that whatever that the judges mentioned here. All right. The parties' respective positions show that they agree that the release language, that is, the phrase "quote could have been included as a defendant" and quote applies only if there is a nexus between the person in question and the claim Ms. Giuffre made against Epstein in the Florida case. They disagree, however, as to the nature of the requisite nexus. Okay, the defendant argued, which is Prince Andrew here, that the nexus is supplied by plaintiff complaint in the Florida case, end quote. Oh, no, that's not a quote. Okay, it charged Jeffrey Epstein to quote the defendant in the case with quote sex trafficking and sexual abuse. What? Okay, it alleged that girls whom Epstein trafficked were abused by others, including unspecified quote royalty. I'm telling you, Andrew's taking everybody down with them. If there was other people, oh yes, yes, yes. What is it? There was something that I saw, and I think I did in one of my video. Is it his cousin or something like that? Was it in the New York? Okay, I have a video. I'll put the thumbnails of it, but I don't know if it's part of that. But there was some stuff that was going on with one of his cousins. Maybe that's what it is. And also, at the same time, Andrew is telling the court that he is part of the sex trafficking thing that Epstein had pled guilty of. So that's what he's saying here. He's doing it without even knowing. So he's pretty much telling the court he is part of the sex trafficking and sexual abuse of young girls, which Epstein have pled guilty of in Florida. So that's what he's saying here. My goodness, this guy, I don't know who's advising him. Okay, so Andrew's taking everybody down with him. By others include unspecified royalty that defendant submits is enough. Okay, from the plaintiff's standpoint, defendant position is too extreme. As noted, the Florida complaint did not mention Prince Andrew. Okay, this I know already. I was aware of that. But then again, it was my humble opinion speaking. Moreover, Ms. Giuffre argued in substance that one, quote, could have been included as defendant, end quote, only if that could have been done on the same basis as the claim in the Florida case was made against Epstein. Violation of one or more of the Section 2255 predicate criminal statutes, and even then, two, only if that person could have been subject to the personal jurisdiction of the Florida court. Yet, there is no basis for concluding that defendant will have been subject to the personal jurisdiction of the Florida court. Nothing in Ms. Giuffre's Florida complaint indicate that the defendant violating any of the Section 2255 predicates, nor it is reference to, quote, royalty and, quote, sufficient to remedy this absence. The crux of the Florida case was that Epstein harmed Ms. Giuffre by trafficking her for sex with himself and with others. Indeed, defendant counsel made clear at oral argument his view that the complaint against Epstein was that Epstein trafficked Ms. Giuffre to a number of individuals, forced her into sex slavery, and forced her to have sex or be sexually abused by many people, including members of academia, including businessmen, and the category of royalty. Okay, all these are potential people, but none of them, no specific name was mentioned. It's just general. Okay, there are plenty of businessmen out there who probably have nothing to do with Virginia, but you can claim to be covered under that. I'm thinking of one, but I don't want to say it because it's not part of this mess here. Yet there is no suggestion in the Florida case that this defendant was himself engaged in sex trafficking. I'm telling you, he just tangled himself. He just proved that alone, what he just did here to cover himself under this agreement is pretty much telling people he is guilty. He has done whatever Virginia have already said. Okay, and considering whether the only reasonable interpretation of the phrase, quote, could have been included as a, quote, defendant, end quote, is the one advanced by the defendant. That is, that it will inherently be unreasonable to construe that phrase as referring only to person who could have been sued in the Florida case on essentially the same theory as was Epstein, and over whom the Florida could have exercised personal jurisdiction. Thank you. He just put himself in more problem. Because if he's claiming he's covered under this, Florida could go after him now. That's the thing that I'm seeing here. Let's say he settled this with Virginia. Prosecution in Florida could go after him because now he's saying he's part of this. You know, whatever Florida government was going after Epstein could easily charge Andrew under the same thing, under the exact same thing, because now he is saying he's covered under this. The same reason that Virginia was suing Epstein in Florida, and then to throw out her case that she had filed. Okay, that was the reason for the agreement came about, to throw away a case that Virginia has filed under Epstein. So Epstein did not want that trial to go forward, so they create that agreement. So now Epstein have said he's guilty of that, and he agreed to settle out of court with Virginia, and then now Andrew is claiming to be covered under that. So now his name was nowhere to be found under the lawsuit. If Florida government wants to go after Andrew, now they have plenty to say, because now he's saying he was covered under this. He's saying he's guilty. He was part of that ring. He outed himself. Okay, let me read that last sentence over here. It is helpful also to consider the context in which the 2009 agreement was signed. To the extent context can be ascertained on the present record. Of course, we do not know what, if anything, went through the parties' mind with respect to the specific term of the 2009 agreement. Hypothetically, we can imagine, okay, we can imagine what someone in Epstein's position might have thought at the time this agreement to settle the Florida case was made. I've said that too. Okay, we could think about it, but he's dead. He can't come here to confirm what he said, what he meant by. But then again, the thing will not ever, the court will never accept it because it was not in writing. Okay, at least some of the goal of a such person presumably would have been to end the Florida case, to gain as much protection for himself as he could get against involvement in similar litigation in the future, and to do so for an acceptable price. Okay, acceptable price. All right, so this is what the judge is saying here. The reason that Epstein settled this is for potential for Virginia not to sue him ever again. But we could assume that, but the other one, nobody can come under the umbrella of this. Okay, in other words, a possible concern could have been that, one, Miss Giuffre, having settled with Epstein, will sue someone else. Two, who in turn might make a claim against Epstein or claim over based on a contention that Epstein should bear or at least contribute to any liability that person might be found to have Miss Giuffre's, Miss Giuffre, obtaining a release from Miss Giuffre or of claim against such a person, therefore, could eliminate the possibility of a claim over against Epstein. But the objective of one in Epstein's position were unlikely to have been shared by the other contracting party, an individual in Miss Giuffre's position, and that matters. Wow. The goal of one in Miss Giuffre's position, hypothetically, could have included getting as much money, as much money as she could for settling the case and keeping as much of her freedom to go after other alleged wrongdoers as she could have keep while still getting an acceptable sum of money. If more people were to put their name on it, so she could argue for more money, but she didn't do it. She just did whatever, that $500,000. Okay, limiting the release language to person who could have been sued in a particular court on a particular type of claim could secure that freedom to the substantial degree. Okay, the logic of the situation. In other words, if more people were mentioned under that agreement, the $500,000 could have been more. All right, so it was just between Epstein and that's it, and Virginia, that's it. So more money could have been offered to her to add more people. Okay, the logic of the situation does suggest that the parties in the 2009 agreement had competing goals, and the modeling release language that they agree upon suggests that they may have arrived something at a middle ground, a release extending not as broadly as Epstein ideally may have wanted, and somewhat more broadly than would have been a, quote, best case, and quote, outcome for Miss Giuffre. It's like they want everything, but they don't want to mention everybody. All right. Let's see here. They may have arrived to some. Virginia came somewhere in the middle to agree, even though I don't think she had a good representative here. I don't think whoever was representing her had her at best interest. Okay, moreover, it will not be unreasonable to recognizing among other consideration that the settlement amount may have been affected by the view of both parties concerning the term of the release. Epstein perhaps will not have been willing to pay a price demanded for the broadest possible release of other persons, or in other words, Epstein will not want to mention all of his clients. All right, so they're playing, they're playing all sort of ways. Okay, or short of that, clearer language concerning the nexus between other potential defendant and court and claim in the Florida case. Yeah, so in other words, I sort of understand what the so since Epstein is not alive to discuss why he was able to pay that $500,000 to Virginia, so the judge is sort of suggesting that maybe perhaps Epstein did not want to pay more than what he was willing to give her, which is $500,000, to exclude all of his clients. So we could assume as many scenarios as we can, but the fact of the matter is what is written on the document is what the judge can only accept. We cannot assume just because they say something and this is what they mean. But if they didn't mean what they say, they should not mention it. So Epstein wasn't willing to pay a lot, or maybe Virginia wasn't willing to accept the amount that Epstein had offered her to exclude all of her abusers, this kind of thing. So this is something I sort of think that the judge is trying to say. That's my understanding of it. Because they don't mention other people's name in here. So if, for instance, Epstein were to mention more names here, the money will have been much more. But because they limit the $500,000, so it only affected in some ways. I don't think I'm explaining my thought here. So let me just leave it alone. I'm not explaining well enough, but I think I understand. Okay, there are additionally considerations supporting the reasonableness of plaintiff interpretation of the phrase "quote could have been included" as defendant and quote. For one thing, the Florida case was brought in the federal court. The sole alleged basis of federal jurisdiction was Section 2255 of Title 18 of the United States Code, which confers subject matter jurisdiction on federal courts only with respect to claim based on alleged violation of certain federal criminal statutes. Okay, statutes. Okay, the complaint in the Florida case is specifically alleged that Epstein had committed a number of such violations, but it nowhere alleged that this defendant committed any. So in other words, nothing in the Florida case mentioned that Andrew have done anything wrong over there. So how could he be covered under that agreement? Okay, and the thing is that the thing that the judge is I see here is repeated over and over again. That text here could have been included as defendant. So this is not very well crafted. Could have does not being concrete. So the judge is really focusing on the language here. All right. Okay, it's not clear that a claim in the Florida case against this defendant will have been within the subject matter jurisdiction of the Florida court, even on a co-conspirator. In other words, he could have been part of Epstein thing, all right, or supplement jurisdiction theory. It is questionable. I'm telling you, he entangled himself more. Also, whether the Florida court could have exercised personal jurisdiction over this defendant, even assuming that subject matter jurisdiction exists. I'm telling you, he's putting himself in more problem by claiming this. And the last analysis, it is not now the court's function to decide which party's view of, okay, this is a whole bunch. I don't want to get into it. Okay, the meaning of the term could have been included as a potential defendant in the Florida case properly reflect the party's intent. It is enough to conclude that the meaning of this pivotal phrase on the contract is not by any means, quote, unambiguous and free of conflicting inferences, end quote. The parties have articulated at least two reasonable interpretation of the critical language. So, another word, the judge is saying that there's so many ways the language and this contract could be determined. It could go many different ways. So he doesn't want to give his own conclusion, what he thinks it is. So therefore, is gonna proceed to further trial to explain what those open words, those infinite words could mean. So this is why one of the reasons he's letting it go to trial, because the contract is very confusing. The agreement, therefore, is ambiguous. Accordingly, the determination of the meaning of the release language in the 2009 agreement must await further proceeding. So that's what he's saying. It needs to go further. Some people are like sweating in their pants right now because he just opened a worm. Because this thing, the agreement was sealed. It was sealed. But because he brings this argument here, saying he's covered under this, now people know what's under it, what it means. So before, I could assume when the trial began, the Virginia versus Prince Andrew begins, the first few things they're going to try to argue here, how is this agreement cover Andrew? Now they're going to have to name names. They're going to have to name names. And people, a lot of people don't want to be part of it. And there's possibility, maybe, whoever had any relationship, sexual relationship with Virginia, okay, probably already settled with her. Nobody knows. They probably said, look, don't sue me. We did this, we did that. Let's settle this so we could forget about everything. There's probably things that's already been done. But this guy, he should have just shut his mouth and prove his case or just settle completely. But I guess he's trying to be above the law here. Okay, as very general matter, I skip a lot of things here. I skip that. All right, I'm just because these are references that the judge is making. They probably were also under the agreement that I already read. Okay, let's see here. Whether the defendant is entitled to enforce the release of the third-party beneficiary of the 2009 agreement. And then let's not forget, I don't know if I mentioned it when I did my little rant here, is that the thing was sealed. The agreement was sealed. It was released, last Monday before the thing was heard. The argument was heard in court. Okay, as a very general matter, the only person who can enforce a provision of a contract are parties to that contract, the people who agreed to it. The defendant was not a party to the agreement between Epstein and Virginia. I said this, Virginia Giuffre. They got rid of him, but yet, they thought the things was a done deal. Virginia could sue anybody who they probably talk verbally but never mention on the document, because Giuffre is not there to say his side of the story. Okay. Accordingly, even if the releasing language of the 2009 agreement included the defendant among the person Ms. Giuffre released, the question will remain whether the defendant may take advantage of that release under Florida law. That's what it is. Yeah, he's taking advantage of it. That depends on whether Epstein and Ms. Giuffre intended that he be able to do so. In other words, whether he was what the law called a third-party beneficiary of the contract. It will have to be written somewhere. Okay, under Florida law, it is essential to the right of the third-party beneficiary to enforce a contract to which he or she is not a party that the clear intent and purpose of the contract. All right, so it's not clear. Okay, so it's not clear. All right, let's see here. Was directly and substantially benefit the third party. A merely incidental or coincidental third party beneficiary of a contract may not sue for this enforcement. Yeah, it's saying like it could be just a coincidental that you happen to know about this and then you want to fall under it. They're going to hear what Virginia had to say. All right, relevant provision of the agreement. In this case, there are substantial indication on the face of the 2009 agreement itself that Epstein and Ms. Giuffre did not clearly intend for the releasing language with respect to, quote, other potential defendant in the Florida case. Okay, so Virginia and Epstein have agreed. That's what they're saying here. And that I think that's what I just mentioned here. Because Epstein and Virginia could have easily verbally, okay, verbally agree, do not sue certain people under this agreement. All right, but they didn't write it. So now that Epstein is not here to defend himself, Virginia could say whatever she wants. It's a one-side thing here now. All right, she got the coin on her side. Okay, or the potential in the Florida case, whether that was intended to means to quote directly and quote or primarily and quote or quote substantially and quote benefit those persons. As an initial matter, one reasonably might conclude, although that may not be the only permissible inference, for reasons already stated, that Epstein's purpose in seeking to obtain a release of person other than Epstein and the other quote second parties end quote was primarily and directly to protect himself. Okay, it was to protect himself because Virginia was suing him. It was to protect himself. That is, I did say that. All right, because Virginia was suing him in Florida. So to remove that lawsuit, they come up with the agreement. There it is. All right, from becoming embroiled in future litigation. See, he's not fooling the judge here. The goal, even assuming that the requirement of quote clear and quote intention to benefit the persons released quote primarily and quote substantially and quote were satisfied, which is doubtful. Okay, which is doubtful, will have been served only if persons arguably within the releasing language were aware of it, and if later sued by Ms. Giuffre successfully could have been asserted the 2009 agreement released against her. But the 2009 agreement contained provision that appear to have been intended to make sure that such person will not be aware of the release. So because they said potential. So in other words, there was no concrete name there. So those people, in other words, all of all of Epstein clients are not even aware of this. Okay? So they're not even aware of this agreement, even though Andrew knew. So in other words, all of Epstein's client who probably had any relation with Virginia probably are aware of this agreement. So now the judge is saying, no, we're not buying this nonsense. If you wanted your name to be on it, your name should have been on it. Okay? Even if aware of it, were prohibited from or at least severely limited in the ability to use it indefensively. All right? It's not defensible because no specific name was put here. And most importantly, this document was supposed to be sealed. Nobody's supposed to know it except Epstein and Virginia. This is very important here. This document, nobody should be using it, should have known of it except Epstein and Virginia. That's it. So how did Andrew know about it? Okay, that's a huge question for him. How did you know that you were covered under that when your name is not even on it and it was supposed to be sealed? So there's some stuff here. He put it here based on the agreement. Okay, so both Epstein and Ms. Giuffre were prohibited from providing all or part of the 2009 agreement, even to anyone who might have been among the personnel possibly included within its releasing language. Okay, the second is a portion of Section 2, the releasing provision that provide additional, that's in quote here, additionally, as a material consideration in settling first parties, Ms. Giuffre, and second parties, Epstein, agreed that the term, all right? So first and second party agree this. That's them here. The name that's concrete, the judge are aware of. Okay? Settlement agreement are not intended to be used by any other person, nor be admissible in any proceeding or case against or involve Jeffrey Epstein, either civil or criminal. So that's that. The judge read the things very clearly here. All right. So in other words, this was between Virginia and Epstein. So Virginia cannot sue Epstein ever again after this agreement. But no way Andrew's name was mentioned here. Okay? Taken together, this provision, at least reasonably, could be interpreted as meaning that Epstein and Ms. Giuffre agreed that one, neither will disclose the 2009 agreement in whole or in part to anyone except upon compulsion of legal process, which is why they release it. What is it? There were two judges that agreed to release this agreement, and this is how I came about it. I came across it because it went to court for it to be released, and this is why I was able to read it. And this is what the judge is saying here, because now Virginia is suing people, is suing Andrew, and Andrew is saying he's under that. Okay, he is covered under the agreement. So because now it went into question. So now this is why Virginia had to go to court and ask for it. I believe I could be wrong on this. I could be wrong on this, 100% wrong on it. I don't know who requested for the agreement to be released. It will have to be Virginia, because if she's the one who's suing, maybe it could have easily be Andrew. Maybe it could be Andrew, because now he's saying he was covered under it, and then Virginia saying, no, you're not covered under it, and then for a matter of fact, so now it went to court for it to be made public, and then they release it, and that's how I was able to see it. So I don't know who, okay? I don't know who requested to go to court for it to be released, all right? So this is question mark here. I do not know, all right? But I read it in the agreement that only what the judge is saying here, all right? As a matter of, what is it? Okay, I read it already. What is it? Epstein and Virginia agree neither will disclose the 2009 agreement and in whole or in part to anyone except compulsion of legal process. So right now we are in a legal process here. So Andrew claimed he's part of it. So they probably said, okay, we need to bring this to court. Let the judges see who's right or wrong. Okay, 2, no one was intended to use the term of the 2009 agreement, which of course included the release language upon which the defendant relies in any proceeding or case involved Jeffrey Epstein. Yeah, I did say that. Okay, defendant nevertheless contend that the Florida courts have, quote, long recognized that an intended third-party beneficiary of a board release has a standing to enforce that release, even when the release does not identify that third party by name. Yeah, no, he's saying he's covered under it, but there was no name in it. By saying royalty doesn't mean you are part of it. All right, so now he put himself, in my humble opinion, I think he put himself in more problem. He should have just dealt with that, with the lawsuit, settle it, and don't try to be a smart Alex kind of thing. Because now Florida could go after him, okay? Meaning Florida government, okay? That is at least an unduly broad generalization. The first case he cites, Olsen versus Connell, held that purchasers of real property were third-party beneficiary of a contract between sellers of the property and holders of an existing judgment lien on it. There, however, the court indicated that the agreement existed only as, okay, so this is another example that the judge is using as an example for his conclusion. All right, so this had to do with someone who's buying property or something. Let's see here. All right, only as a certain jurisdiction, the parties and any third party agreed that the state courts in Palm Beach County shall have exclusive jurisdiction over the subject matter and shall have personal jurisdiction over the parties and third parties. Okay, so he's saying here, in other words, New York doesn't recognize a third party, what was written on a Florida case that was subject to. All right, as an initial matter, the parties to the agreement had no authority to bind third parties. To be sure, the court recognizes that defendant's point is different with that the references to third parties, 7, evidences intention to benefit others, okay? Perhaps, but it does not inevitably follow that the benefiting Prince Andrew or other in comparable position was a primary purpose of the release. Okay, but it does not inevitably follow that benefiting Prince Andrew. Okay, so they don't know. Okay, so the thing that the agreement between Jeffrey Epstein and Virginia Giuffre was not intended to benefit Prince Andrew. I mean, they were looking out for him, but yet he put himself in it. My goodness, who is advising him over there to say just settle it and stop arguing with them? Because they were looking out for him, but now he's saying he's part of it, so they could come after him. So since you say you're a part of it and Epstein is dead and he had played guilty for being a sex trafficker, so you probably are too. Oh my goodness. Complicating defendants argue even further is the way in which the term, what is that? Is it enforcement? Okay, I don't know if it's a O or, okay, I guess enforcement, and third party are used elsewhere in the agreement. Section 4, the only other section to use the term third party, purport to create a right and obligation with respect to disclose of the amount of the settlement, the reciprocal confidentiality covenant provides, quote, any third party who is advised of the settlement amount must sign a document acknowledging that such third party is aware of this confidentiality provision. In other words, the third party should have signed that agreement. His name is nowhere near it. He didn't sign it. That's the thing here. He didn't sign it. Okay, and is bound by it. So because his name, yeah, I did say his name is nowhere near the agreement. Why is he going under that umbrella? He never signed it. Okay, including the provision contained in the settlement agreement relating to the enforcement of this confidentiality provision. Okay, there's some section here. It would be eminently reasonable to interpret 7 references to the third parties and enforcement as referring specifically for reciprocal confidentiality provision, which in addition to employing those two terms together is the only other place in the agreement where neither term appear at all. So in other words, they didn't say his name anywhere for him to go under that, to be covered under this agreement. Okay, what is more, 7 specified that if a breach of confidentiality were to occur, only, quote, the aggrieved first or second parties may seek a remedy with the court. No third party right attached. Okay, his name is not attached. They don't recognize him in there. Oh my God, he outed himself. He outed himself. Necessarily part of the impending sale of the property of the third party buyers. Okay, so I read this. So this is where he mentioned about another lawsuit that happened. He used as a reference. So let's go back to this. There, however, the court indicated that the agreement existed only as a necessary part of the impending sale of the property to the third-party buyer. The seller had sought the agreement only because they, quote, they could not consummate the sale of the property without attaining the release of the judgment lien, end quote. They made the deal with the judgment creditor. Okay. Quote, in order to affect the sale to, end quote, the buyer. Okay, so, okay, I'm a little bit confused with this, but let me just read. The buyers, the unnamed third party, were so integral to the deal between the seller and the judgment creditor that the court hypothesized that they were, quote, likely even actual parties to the agreement as evidenced by their execution of the note and mortgage payable to seller and their closing of the sale and reliance upon the agreement. This case bear no resemblance to Olson. Okay, so okay, he was comparing third party kind of thing here. So this does not reflect what third party is. Okay, so because documents need to be concrete with names and stuff like that. So I sort of understand, but I don't want to try to interpret it because it's not part of this. Okay, defendant point next to Hester versus Gatland and Dean Burnett versus Milford, Inc., both of which involve auto accident with multiple potential tortfeasors. And Hester and Hester, the owner of a car involved in a multiple car accident, was held to be third-party beneficiary of a release agreement that had been executed between the plaintiff in that case and other drivers who were involved in the accident. There, the release language extended to, quote, any and all other persons and or corporations who are or may be liable for injuries or damages sustained as a result of the subject accident. And then a court held that the employer of a driver who caused a fatal car accident was third party. Okay, I see what's happening here. As a court held the employer. Let's say, for instance, I don't know exactly how this went about. Let's say a delivery person who was driving for, let's say, for a pizza company, who was delivering pizza, and that person, the driver, the delivery guy, caused an accident. So the third party, which is the owner of the pizza place, all right, is considered a third party. So that's what I'm getting here. Okay, that's my spin on it. Okay, beneficiary to a settlement agreement between the driver's insurance company and the administratrix of the victim's estate. Okay, the settlement there include general language releasing, quote, any other person, cooperation, association, or partnership charged with responsibility for injuries to the person and property of the undersigned and the consequences flowing therefrom as the result of the fatal accident. Okay. As Ms. Giuffre, okay, he's using different cases that happen elsewhere as his how he come to his conclusion, and also as a way wording into a contract was made, which also bring into light the wording and the 2009 agreement between Jeffrey Epstein and Virginia were not really specific, but those examples he's using were more concrete where he could go about. So in other words, Andrew is not included in that agreement. Okay, as Ms. Giuffre observes in her brief, the Hester and Dean releases were confined to discrete event on a specific day. Identifiable subject accident circumstance circumscribing narrowly the subject matter of the purportedly released person or claim. So they too are an opposite here. And there is a further problem common to all defendants' cases. None of the cases that the defendant cited dismisses claim against the defendant putative third party. Whatever Andrew just did here, he pretty much strengthened Virginia's case. And this is what I'm saying. Even if, Florida was trying to protect Andrew, what he just did here, he pretty much opened himself to more lawsuit from the U.S. government. Okay, let's see here. Defendant putative third-party beneficiary who asserted a release defensively at the motion to dismiss stage. Okay, Prince Andrew's view of, quote, other potential defendant, and, quote, on the other hand, seek to confer right on unnamed third parties that will be order of magnitude border those contemplating in any of the Florida case that have been brought to this court attention. Moreover, whichever was this comparison break, they matter little on the fact that of this case. Oh my God. So the judge is saying whatever he's saying here, it mattered very little. They don't recognize his BS. Okay. Moreover, whichever way this comparison break, they matter little on the fact of this case. In other words, he pretty much strengthened Virginia's case. The ultimate goal in any case involving a contract is to determine and give effect to the, quote, intention of the contracting parties. Okay? So in other words, the court, for looking into a contract between two people, is to make sure what the agreement was intended for is what it is. Okay? So the judge should not be giving preferable treatment to anybody. It's just to interpret the meaning of the contract, which he did. Okay? Unlike the cases cited by the defendant, all right, where the parties' intention were perfectly plain, at least by the time the cases were decided, the intention of Ms. Giuffre and Epstein concerning the release or anything but clear here, at least okay, this stage. The case, in other words, at this stage, him hearing what Prince Andrew have to deal with, have the argument that Prince Andrew is brought to the court for the thing not to go to trial. So at this stage, pre-trial, that's what it is. Now, during trial, if this goes to trial, it's to explain what this agreement meant in more detail. And this is where people's going to be very scared about that because they don't want people to mention names here. That was the full intention of that. And then anybody who were involved with Virginia are going to shut their mouth. Okay, the Dershowitz argument. BBC bought him, and now his name is in this court document. Let's see here. The Dershowitz argument. Finally, the defendant nevertheless argues that his interpretation of other potential defendant clause is the only reasonable one on the basis of alleged event relating to Alan Dershowitz, a lawyer and a retired law professor whom Ms. Giuffre had sued in other case. Wow. I didn't know about that. I know he was involved, but I didn't know Giuffre was going after him. No wonder why BBC quickly brought him over there to talk this nonsense. Oh my goodness. But his name is in this here too. Okay, defendant assert that Ms. Giuffre could dismiss her claim against Professor Dershowitz when this release was raised to her as a potential defendant. Okay. This, according to Prince Andrew, proves that the 2009 argument released Mr. Dershowitz, and by parity of reasoning, the defendant in this case, the theory apparently being that both were other potential defendant in the Florida case. You don't know what went behind the scene. Maybe there is another agreement between Dershowitz and Virginia for her not to go forward with that. And then now Prince Andrew, not knowing what were done privately, is inserting himself in more things. This guy is a fool. Who is advising him? A lot of things could be done privately. Nobody knows. So there must be a reason why Virginia Giuffre did not pursue Dershowitz. Maybe there was some sort of agreement that was done privately. Okay, that's just my humble opinion. But now Prince Andrew is bringing everybody down. Let's say if, for instance, Virginia were to sue Dershowitz, let's say if something had happened with her and Dershowitz in New York and decided to sue Dershowitz, now we're probably going to know what was done privately, if there was some sort of agreement. Okay, after this, I'm going to go to video 3. Okay, during our argument, the court questioned that argument based on its suggestion that Mr. Dershowitz was covered by the release and the 2009 agreement because he has been one of Epstein's attorneys. Okay, like I said, and when I was reading the agreement, I said something. I have a feeling he probably was the one who voted. And there it is. They mention here. He's one of Epstein's attorneys. So there's a possibility he was the one who wrote the thing, but New York doesn't recognize that. And therefore was among the second parties. In other words, that he was covered by the release independent of whether he was other potential defendant, as the defendant now claimed that he is. On further reflection, analysis, however, the suggestion that Mr. Dershowitz was covered because he was one of second parties was not necessarily correct. All right, it's not correct. So the judge is saying, you're not right to bring him here because for the same reason your name is not signed in this document and Dershowitz's name is not signed in it as a potential defendant. Okay? His name, there's a possibility. I didn't really look closely the signatures of those attorneys. If his name is signed, let's say Dershowitz, who is Epstein's attorney, his name is in the document as Epstein attorney. Okay, there's two different here, as Epstein attorney, but not as part of the potential defendant. He's not covering this. Okay, I forgot to look closely into it. I just brushed it off. It's in the document, but I didn't look closely into it for me to see if his name as Epstein attorney was signed in the document, the 2009 agreement. So if his name is signed here, they probably just fool Virginia on this for not suing Dershowitz because his name was signed there as the attorney, but not as defendant. All right. So the judge is saying here, second party Dershowitz. Okay, let's start here. However, the suggestion that Mr. Dershowitz was covered because he was one of the second parties was not necessarily correct. All right. So the judge is saying he's not. Okay, it's not correct. Is not covered under it. Okay, a release has three essential elements. One, who gives the release, usually referred to as a releaser. Two, one against whom the releaser gives up or surrenders something, such as a person usually being referred to as a releasee. And three, a description of what is being released, which may be general, that is, all claims whatever that the releaser has or may have against the releasee. Okay. Whoever decided to release the agreement must have something against the releaser. So this is where I was saying, who released that? Who bought this for the 2009 agreement between Epstein and Virginia, brought to court for it to be released? So this is the question here. So we might get the answer here. I did raise it. Was it in this video or video one? I'm not sure. Or specific, that is releaser's claim for damages caused by the released motor vehicle. Okay, and section 2, the category of releasor is plain enough. Quote, the first party, end quote. So that's probably Virginia. Okay, there also is a description of the releasee. One, quote, the second parties, and two, any other person or entity who could have been included as a potential defendant, other potential defendant. The problem, however, is with the claim against the second parties other than Epstein. This is where the problem here. People cannot claim to be covered under second party because Epstein is not there, because the thing was between Epstein and Virginia. And the whole reason for the 2009 agreement was to for Virginia not to pursue her lawsuit with Epstein. Okay, that purposely were released. Specifically, section 2 says that the claim released were claims that the first party ever had or may have against Jeffrey Epstein or other potential defendant for, upon, or by reason of any matter, cause, or thing whatsoever. Strikingly, it does not say that the first parties released the second parties. You started getting confused. Just know first party is Virginia, second party is Epstein, okay? Other than Epstein personally. Okay, as such, from any particular claim at all, whether all claim or some specific claim, accordingly, element 3 of the essential element of a release, the specification of what claims against the second parties were being released, is missing as to the second parties. Accordingly, it would be reasonable and did arguably unambiguously clear that the 2009 agreement did not release any claim against any second parties except for Epstein himself. Okay, I need to stop because I'm already an hour. And two, those second parties other than Epstein, who in addition to being second parties, came within the definition of other potential defendant, whatever that is. Okay, so with that being said, I'm gonna stop, but we'll continue and video number 3. All right, let's do a prayer here. Let's do prayer for let's say for judges. Okay, I have it here. For judges to do the right thing. Okay, when people go to court, we need judges to do the right thing and not to be influenced by money. Okay, let's see this one here, and then I'll go to image. Prayer for justice. Okay, prayer for our justice system. Almighty God, you are a God of justice and righteousness. We pray for the justice system in our country. Yes, we need to do that because too many people are doing bad things and they want to get away with it. We want their moral, the reason why judges decided to be in the justice system, to consider to do the right thing. All right, to keep their, when you're a child, when kids say, oh, I'm going to be a police officer to go after bad guys. So this kind of intention remain with those people who are in the position of why they wanted to be who they are now. So for those judges to do the right thing, to see justice the way that it should be, to be fair. In other words, to be fair. Let's do, I'm looking at this one and that one. Let's do the green one, and hopefully I remember. Okay, and the second one is right here. Pray for courage to do the right thing. Oh, Heavenly Lord, I feel that I am being torn apart. Okay, I know what's right, but it won't be easy, not at all. I admit it. I'm afraid. Won't you help me? Reveal to me, O Lord, your way. Show me the firm, solid path. It may not be easy, but it's where Jesus walked. He's right there next to me. And when the climb gets steep, my Lord will lift me, carry me, for this weak and fragile soul can't do it alone. I trust and lean on you. Build my courage to face the day. Let it not fill me with pride. Instead, may it be humble, knowing that in some small way I imitate Christ. My Lord Jesus held nothing back, as it was all for love. Okay, for those who decided to be in whatever position they are, especially in the justice system, whatever love that you have for it, make sure you stick to that. Okay, your principle to do the right thing, morality, core values. Okay, may I too go to the cross, be driven by love, and give glory to Lord. In Jesus' name, I pray. Amen. This, you know what? I'm not gonna read that because it seems like it's going for the other one, because their family are always together, with the exception of what they did to Megan. But I'm just gonna stick with the first one. All right. So please take a moment to subscribe, like, and share. If you want to support this channel, there's a PayPal link in the description. You could donate, and or if this channel is monetized, you could watch the commercials. So that's it. I'm gonna go to video 3.
Harry, sit down. Just sit. Just sit. Harry, sit down. Just sit. Just sit.
It is a great privilege to be with all of you today.
You know, we ask for forgiveness, and please come back.
As you saw me find the love and happiness that I'd hoped for all my life. You are all in this together, and if I may speak personally, we are all in this together. The because asking for help was one of the best decisions that I ever made. You will be continually amazed how life changes for the better.